Our next speaker is Danny Martinez, who comes from New Mexico. He's a rancher there and has worked closely with the Hayes family in dealing with their legal issues. And in that process and in other contexts, he has gained much information and knowledge about the legal process and the abuses brought to us through our government of that process. And I think his message is going to be that we've got to know our rights, preserve our rights, and that's what all of us as American citizens need to do. So, Danny?
Thank you, Michael. My fight is, or my conflict basically has to do with property rights in Arizona. And when this all started, I had attended a seminar put on by Mr. Hayes and Ramona and Helen. That was back in 2004. I attended it. I saw what my dad was going through. I understood what was going to be happening. We were starting to put the pressure on him. All the property was put in my name so I could defend it. And at that time, I started looking for ways to educate myself to try to defend the property. It's like Mark Twain said, you know, if you hold a cat upside down with a tail, you're going to learn things you never ever thought were possible. And some of the stuff that they did, they try to break you by putting pressure upon you, just like the wolves do. You know, it affects behavior, it affects your lives. But the first thing they started to do was they gave a brother of mine a criminal citation for working on a RS 2477 road. It was a right-of-way into the ranch. Well, after 8 months, I defeated that without him making an appearance in the court. The next thing they did, they came after me under the Endangered Species Act. But all this time, I anticipated what they were going to be doing. And so I was sort of prepared, knowing basically what I had experienced and I had learned. And I understood that the Endangered Species Act was really a federal municipal law that was primarily restricted as to territorial. It was territorial law. It was not anything that was enumerated in the Constitution. So that was my defense. What I saw there, that the agencies they team up with the state Fish and Wildlife Service. That's the conspiracy right there. That's the nexus. And the next thing they do, they're in collusion with the environmental groups. It's the environmental groups that sue the agencies in order to deprive somebody of their property rights. And I learned that too. So the first engagement was a 60-day letter of intent to sue. And I was already prepared for them. So when I got that letter, I immediately responded by asking them questions under the rules of civil procedure. I immediately could start discovery because that was the commencement of the action according to the Endangered Species Act. So when I brought up certain issues about that case and the liability of the environmental group, they decided that was not a good thing for them to do. So the next thing they did, they came after me on a letter of trespass. The U.S. Attorney from Arizona sent my family, they sent everybody in the family this trespass letter, alleging that they were going to be sued and they could be charged and fined. And so what I did was that was the first letter of engagement. So I decided that I would exhaust my administrative remedies in that case, because it's important. What I had learned when I took the seminar from Wade Hayes, I understood that we had property rights. But what I felt was missing out of that. There was no remedy on how to protect those rights. And that was primarily my focus of all my studies and everything, was I was looking for the remedy within the law to defend those property rights. And that's primarily what I learned. So what I responded to the U.S. Attorney's Office, and I had to do paperwork for everybody because I understood all the issues and the laws and they didn't. But after that, I requested a procedural due process hearing, which is mandatory under the Fifth Amendment, and it's also mandatory under the Administrative Procedures Act, which was binding upon the agencies. So what I wrote them a letter and I asked them that we could settle this thing amicably. There was no point for litigation, that if they had a better title than I did, and I had equitable title, and I asked them, I said, look, if you got a better title than I do, it's no problem. I'll gladly concede. And then I said, but I would request a due process hearing, and we can settle this. But then I asked them, before the hearing, so that I might understand the nature of what you're asking of me, I want you to answer some questions for me. There was 80 questions I asked them, and I knew the answer to every one of them, and I knew that they didn't have the jurisdiction or the authority to even be asking anything of me. Well, they would not respond. They kind of went silent on me. I reminded them, hey, listen, we can settle this. You're in default. I'm going to give you 10 days to send me a response. They would not respond. So because they would not respond, the U.S. Attorney was collaterally stopped from filing action against me. See, everything was procedural. So then the next thing is the agency, the federal agency that I was involved with in the conflict, had withdrawn all of their corrals and everything, and they were going to come and steal my cattle and everything else. But I understood I had property rights, and so I was adamant about protecting them. And so they came at me with a vengeance you wouldn't believe. They had me in 3 federal courts at one time. And there was days there that I thought maybe they were winning. And then I talked to this friend of mine who was back in New York, and he belonged to a law group that I belonged to. We were sharing information. He told me, he said, Danny, I think you're winning. I said, he thinks I'm winning? He said, I think I'm losing. And because I felt so much stress in my life for that. And I'd get a good night's sleep, and the next morning, I'd wake up and I'd ready to take them all on. As a result of that, 2 of the cases were not, they didn't prevail in those. The 3rd case, they did default me on the case. That's another story. Right now, I've got a case before the Federal Court of Claims on exactly the same issues. So I've got 1 published opinion. I've learned from the mistakes of others. I've learned procedurally how to defend myself. The one thing I did learn is that our remedy is in the laws. We have to read them. I studied statutory construction and interpretation to understand how Congress makes laws and what they say and what I should be looking for in all of these laws. Now, my rights, I've got property rights out in the public domain. All of them are attached to water. Because in the West, water controls the land. And I understood all of that. I have a right to use that water. The government has recognized it. The federal government has recognized it. The state has recognized it. And all subsequent public land laws have recognized it. But I had to read them all. In this process, I was a board member on Paragon, which was a foundation that was involved in some of these legal battles. And then I met a lot of people that were commissioners in the county, there in Otero County. they approached me, asked me if I would consult with them. And I said, yes, but you know, you've got to understand that when I studied the law, the Arizona Constitution at the time, because this battle is in Arizona, it said that the Constitution is the highest law of the land. So when I started my studies and looking for my remedies, I went to the Constitution. Simple. It's written in the common language. But the problem is we've got to read that and understand what it is. What I learned is that all law flows down from this document. That the federal government is a government of enumerated powers. If anybody can hear me, I can speak quite loudly. Can you hear? Okay. What I learned is that. Okay, how's that? It always works. That barbed wire. What I learned is that I would go to the Constitution first to see if that legislative act that they were trying to impose on me was under one of those enumerated powers in Article 1, Section 8. If it wasn't, it really wasn't applicable to me because my business and my residence was within the boundaries of one of the sovereign states. That was the main issue that I learned. The next set of laws that I went to was the Supreme Court, because that's what I was interested in. I was interested in how the Supreme Court interpreted all these laws. So normally in my pleadings, I won't hardly go below the Supreme Court in any of the laws I use. If I may go to a ruling out of the Ninth Circuit, because I know that the Ninth Circuit is going to be binding precedent on any case in Arizona or Nevada. But that's what I've learned. It's really the remedy. Otero County had a problem there, Lincoln Forest. It had a tremendous fuel load, and it was just an accident waiting to happen. So the commissioners want to do something about this. And so I told them, I said, look, whatever you do, we have to follow the law. And so I researched their laws, the Forest Management Act, all these laws that make it mandatory that they manage the forest. I read the Multiple Use Sustainable Yield Act. I read FLPMA, that's Federal Land Management Policy Act. I read them all. So everything that I advise the county is in compliance with every one of the federal and state laws that they're using. The county had a right under the 10th Amendment, the police powers of health, welfare, and safety to abate that nuisance. So we put them on notice that if they didn't do what the law mandated them to do, that the county would do it. And right now, the county is clearing. They're started with around the small villages and cities within the county where the huge load is. And so it's working. We had to bring them to the table. They huffed and puffed and they threatened and everything else. And what the county we did was we went and got the U.S. Attorney involved in New Mexico and forced them to come to the table. So that is working. The Endangered Species Act. We heard Mr. Anderson talk about the wolf problem. The same thing happened in the county. There was 2 wolves that were identified, and so the county called the Federal Fish and Wildlife, said, "Did you guys plant 2 wolves in the county?" And of course, they denied it. And the county said, "Oh, okay, they must be feral dogs. We're going to have them exterminated." They immediately came and removed the wolves. So then I advised the county that they needed to pass an ordinance that would prohibit wolf introduction into the county. They did that. Then there's a mesa down there that's got a lot of oil and gas, so Tera Mesa. They wanted to create a monument there. And then I researched that law and found out that one of the acts has to do with antiquities in order for them to create a monument, and it was only restricted to something that might be like a cave that's got petroglyphs or something in it. It couldn't be just a land grab of land that would grab it and deprive all those rights out there. So they passed an ordinance to stop that. That went away. So what I'm saying is that we've got to educate all our public officials, the counties, the sheriffs. There's a case in Nevada, this friend of mine, when the county failed to protect his property rights and to do what the law clearly mandated that they do, we sued the county. Boy, that really stirred things up. Really stirred things up. The sheriff there's a lot of public lands in Nevada. So they think that they have all this authority over these lands, but they really don't. And it's the county's job to protect them. They threatened a cattle confiscation after that. Before that, the sheriff was just a real nice man. He was very passive, didn't want any conflicts, you know. And once the county got sued, and they realized that they are the ones liable, the next time they threatened, the Bureau of Land Management threatened to confiscate any cattle, he sent them a letter and he said, "Not in this county, I will stop it." But before that, you couldn't get him to take a stand on anything. So my philosophy, or my theory, is it's really our local government that has been authorized to protect these property rights. The wolf introduction is a sham. Do you think for a minute that this gentleman, Mr. Carey's property rights aren't being violated? They are. They're not following their own laws. And see, that was my remedy, and everything that I have learned. And I've learned another thing is that a lot of problems were because attorneys were taking cases into federal court arguing federal law. Well, federal law is what it controls. It is state law. And once we understood that was what was going to be the rule of decision in these federal court cases, the trespass charges against the Hages had to be determined according to state law. Well, there is no trespass under state law because state law recognizes when you appropriate your water vests, you've got the right to use all the land around it to put it to beneficial use, including the land of the United States. I mean, this is the appropriations doctrine that was adopted in the West. Now, California has a blend of both riparian and appropriation water law. It's a blend. But Nevada rejected that, Arizona rejected it, New Mexico rejected it, and that's primarily what we're learning. Now, this foundation that we have, I think that the purpose of it is really to catalog all of these laws that affect the people and their property rights, and to bring in good science like we do in the Endangered Species Act to defeat this. Otero County has been very successful in defeating all of this. I had a rancher there that had received a 60-day letter of intent to sue for that Mexican spotted owl. That was when I was on Paragoran. They had a quote from a Washington law firm. They wanted $350,000 to defend them against that lawsuit. We got it taken away and dismissed. It didn't cost the rancher anything. It didn't cost Paragon anything. And we did it through the administrative process, which is very important. The moment they engage you, there's a procedure for everything that we do in law. And and talk about these wolves, I really think that we ought to have them introduced in Santa Cruz County, don't you?
Yes.
Hey, I understand that that tree huggers make good beef because they don't, you know, they're always telling us that these wolves don't even eat beef. That they're not really a threat to the livestock industry. You know, throughout my studies on all these laws is that I realize that we are not defending ourselves properly. One time you're sitting in a Forest Service meeting trying to negotiate a position on cleaning up the forest, and I was just sitting there because I was just a consultant. I wasn't speaking for the county. But after it was all over and I asked a small little questions, I said, I addressed the assistant regional forester and I asked him, I said, look, why don't we just implement the Regulatory Flexibility Act? We can petition for flexibility on all these regulations because of the problem we've got. Well, I'm telling you, they didn't want anything to do with that. You know why? Because it hampers them. You know, introduction of wolves. You know, they give us notice that they're going to introduce them. They tell us they're going to do it, and we just sit there. We don't know what to do. But there's a procedure for that. Before an introduction of wolves, they have to do an EIS, environmental study on that. They're telling me that I need to address the road closures. You know, they may or may not have the authority to close a road, but they have no authority to close a right-of-way. And we establish what a road a right-of-way is because the right-of-way is called a revised statute 2477 right-of-way. This was recognized by the July 26, 1866 Mining Act. I refer to it as the Mining Act, but that's just only an acronym of what it really says, or what it's about. But what they do, they misapply FLIPMA. See, the Forest Service says they're going to close these roads. The BLM will say they're going to close this road. Well, the law is pretty adamant about that, but FLIPMA it also prohibits that because it says anything built prior to 1976 is already grandfathered in. But see, the agencies tell us that part of the act has been repealed. Yes, it has. We're not even disputing that. The problem is that that's a property right. It's a right of way. And it's a right. It's not a privilege, it's a right. And in order for them to, we acquired that property right at the time the road was built. You cannot go backwards in law and extinguish a right. You can't do it. See, so we've got to be careful of that. Their own statutes say that they are prohibited from that. The Secretary of Interior did a Secretary's final ruling in 2005. She made it clear that the rules on closures only apply to anything built after 1976. So when we know the laws and we can document them, and that's a function of that chain of title. So we can establish when and where all these rights were acquired, and they can't go backwards on them.
Tell them the county has all those records on that.
Yeah, the counties will have every one of those records. And if not, they have them. You can do a FOIA request for them.
What county departments? Caltrans? What county department would
It's
it?
usually in the assessor's office.
Assessor's office. Okay. Recorder's office. Okay.
Yeah. Well,
And/or.
the assessor has it.
And/or.
As well, or the recorder.
We'll do and/or.
Yeah. Let's see, there was a question about cattle trails. Oh, cattle trails. That's a right-of-way. The reason it's a right-of-way is because what was the mode of travel at that time? Horseback? It's a right-of-way. What it means is a right-of-way, you have a right to access the adjacent public land. Or in this case, it could be adjacent lands. If it's on private land, and it was there prior to that, or if it was on patent land, and the owner of that patent allowed people to cross it, and it had already, it's called the doctrine of prescription, or prescription. I mean, you can't extinguish that because it already is developed into an easement, a prescriptive easement. So if we have private property, we've got to be careful on if we allow people to travel across it, because then that establishes an easement across the property. Any other questions I might address, sir?
Right your own back country down there in Arizona, I've got friends that got about 30, I have it, the Secretary of State, they came in and encompassed.
They did.
They have encompassed his ranch with a national monument. All well and good. But the road going into it off Black Canyon Highway, they maintained themselves. Since they made that a national monument, he can't even grade his own road without a federal permit. And he's been threatened several times. Now, how does that work when they make your ranch part of a national monument?
Well, so you got to go to the law of the case, right? Like I was saying. First of all, the creation of a monument, what is it entitled or not entitled the federal government to do? If it is in fact an RS 2477 road, you have the right to maintain it. Now, if they say, no, you need a permit, then they are outside of any delegation of authority to require it. The problem is that if people don't understand what the laws are, and they tell you that, it causes stress, and we just don't want to bother with it. We'll go get their permit. Well, when you get the permit, you waive any rights you have to the road. It becomes a Title V right-of-way. I mean, it's not a Title V. It becomes a Title V use, which is privilege. It's limited in scope. They can tell you, well, you got to apply for a permit every year. Now, you can go back and undo that by giving them notice if you want to take them on. But in my case, you know, when you have knowledge, it builds confidence. Without the knowledge, it creates fear and stress. So the key to this whole thing is for us to educate. Thomas Jefferson said, a people that are ignorant and free is something that never was or never will be. We cannot be free until we educate ourselves. It's the law that's going to set us free. And I grant you, yes, it's a lot of reading, and it's a, but I think that's the purpose of what we want to do, is to catalog these laws and then put them all together. And then you've heard about the Unlawful Enclosures Act. We always hear about that. They say, oh no, you can't, okay, yeah, well, we agree, you've got that section out there, but you can't enclose it. And so then you read it, and so we don't enclose it. But if you read the law specifically, it exempts the settlers. Well, when you buy these ranches and allotments, you're buying those rights. You are you're buying those rights. See, it's a transfer. And that predecessor, settler, is called your predecessor in interest. You have the same rights he did under the law.
See, this ranch is a Spanish land grant. So he's got
Dan?
4 generations.
Oh, yeah.
But they come in with SWAT teams and all.
Oh, yeah, they do. But that doesn't mean that you can't defeat them.